a special guest today, Aaron Burry from Willful. We actually had Aaron, I think about a year ago, and it was really well received from all of you. I'm still getting emails and messages from people saying, you need to have Aaron back on, but please have her back on. So we're excited. Aaron's been really gracious with her time to come on, share more about wills and what's going on with estate planning. This is such an important topic because you can do everything right with your finances. You can invest, you can have a retirement plan, you can have your real estate all set up. But this one area can, if not done properly, can ruin everything. It could just be a huge stress for you and your family. So we're bringing on an expert to talk about this and a little bit about Erin. She's been at Willful for 2-3 years now, and she's a speaker right across the country. The reason we love having her on is she's able to take this topic of wills that isn't the most exciting topic in the world and make it exciting, make it interesting. She's a great speaker. She's been featured on every news outlet you can imagine. And so welcome, Aaron. Thanks so much for having us. And in the chat box, everyone, just say welcome, Aaron. Let's give her a warm welcome. And I'll just hand it over to you, Aaron, and let you do your presentation. If you have questions, just put them in the chat room. We'll do a little Q&A at the end.
Wonderful. Well, thank you, Aaron. And thank you to Enriched Academy for having me. I'm really excited to be here, to be back a year later talking about estate planning. If you see me look off to the right, it's just because I have a second screen here. I'm going to keep an eye on the chat. So please add questions. There are usually lots of questions about wills and estate planning. No question is dumb. Throw it in there. I'll either address it as I go, or we'll leave time at the end to come back for Q&A. I am joining Rhonda. I see you're from Owen Sound. I'm joining from beautiful Prince Edward County today, which means that if rural internet becomes a problem, be patient, but so far, so good today. So we are here to talk about the basics of estate planning and how to make a will in Canada. So first, kudos for showing up to this topic because it's not always the sexiest thing to talk about. This summer, I'm sure you were more concerned with cottages and getting lots of sun in versus checking off to-dos like getting a will. But now that we're back into the fall season, it's the perfect time to be thinking about it. And today, what I'm really going to talk to you about is, yes, a little bit about our journey, my husband and I, and why we started Willful and why we're so passionate about estate planning. But the majority of this presentation is really about the basics of creating a will. It's not about using our platform. It's just about why you need a will, what the components are, and hopefully you can leave at the end of this session and feel a bit more empowered about your next steps, whether you're updating a will, creating one for the first time, or whether you can just pat yourself on the back because you've already done everything I'm going to talk about today. So a bit about our story first. I often get asked by people, do you have a background as an estate lawyer? How did you get interested in wills? Why did you decide to make that your life's work? So my husband, Kevin, and I, he's pictured here, we are not estate planners by background. We always say Willful is really for consumers by consumers because we saw firsthand what happens when a family member passes away who hasn't done proper or comprehensive end-of-life planning. So like many of you probably watching, we lost a family member a few years ago, and Kevin's uncle had a will, but he had never taken care of some of the planning outside of that. So the family was really scrambling to find out where the life insurance papers were and to decide on what type of funeral and burial wishes he would have wanted. And there was just so much arguing and scrambling that Kevin kind of sat up and said, there has to be a better way. We're using technology to order food and get things delivered to our homes and book travel. And yet every single Canadian family will be touched by having someone pass away at some point. And we don't have tech platforms that are really helping to make that seamless. So that was really the impetus from the beginning behind Willful, was to simplify end-of-life planning, to democratize it so that it wasn't as inaccessible, expensive, and confusing, and to empower Canadians to actually put their own end-of-life plans in place. So the problem we identified back then, which probably you can identify with, is that as Canadians, we just really aren't thinking about or talking about our legacy. And that's for a simple reason. Nobody likes to contemplate or think about their own mortality. We know logically that we're all going to pass away at some point, but we assume that it's decades in the future. And there's also this weird superstition that if you think about death, you're somehow bringing it on yourself, or, a lot of just attitudes around talking about death and it being a real taboo. If you're part of Enriched Academy, then you really are committed to improving your financial literacy. And a big part of that financial literacy is estate planning, because as mentioned in the intro, you spend your entire life accumulating all of these assets and investing. And the whole point of estate planning is to make sure all that hard work doesn't go to waste. So we did a survey and found that about 57% of Canadians don't have a will. So if you're watching this and thinking, oh my goodness, I don't have a will, I'm embarrassed, don't worry, you are not alone. The majority of Canadians do not. It's a number we're actively trying to change. And 2/3 of parents with minor children don't have a will, and they're arguably the group that needs them most. I'm 8 months pregnant right now, and with our first child, and I can tell you, one of the big tasks at the top of my financial to-do list once we have the baby is updating the will. And I'll talk a bit about why parents need a will a bit later. And of those who do have a will, it's really this set it and forget it mentality. This idea that you created a will 20 years ago, 10 years ago, and it's just sat in a filing cabinet gathering dust. I know that's what my mom did. She, created a will with a lawyer 20 years ago. And even though her life has changed a lot, she's moved, she's, remarried, all of these things have happened in her life, but she hasn't actually updated this document. So if she were to pass away tomorrow, it would be really, really out of date. So it's not just about the upfront creation of these documents. It's also about how to keep them up to date over time so that they reflect your current life situation. So the top reasons for not having a will, we hear these all the time from people. First is cost. It can be really cost prohibitive to visit a lawyer, and not only to get it done right up front, but also to go back in future and make changes over time. It can be pretty inconvenient going into lawyers' offices and trying to set aside time to do this, regardless of the method you choose. And then just complexity. We don't learn about estate planning in school. I wish we did. We don't talk about this at our dinner table. So there's so many myths and misconceptions around creating a will. And people just assume that it's full of legal jargon and legalese and that it's going to be this massive document. And in actuality, as I'll show you today, a will is actually a pretty simple legal document. It's not as complex as I think people think it is. And so our goal is really to reduce these barriers and to ensure that, we can empower people to create their will affordably and conveniently. So why does this matter now? Well, a will is one of those things that's easy to put off. There are probably people watching who have had get a will on their to-do list for years. We often hear things like, oh, I had my first child 5 years ago. It's been on my list since then, but life happens. It just keeps getting pushed down the to-do list. As soon as COVID hit, it really provided that sense of urgency, because all of a sudden it reminded us that the unexpected can happen at any time and that we shouldn't be putting off for tomorrow what we can get done today. So we saw a big influx in interest in wills when COVID broke out, but we've also seen that kind of sustain through the pandemic as people prioritize emergency planning in general, whether that's life insurance, building an emergency fund, getting a will, etc. So again, I'm going to tell you just a bit about Willful's product, and then I'm going to get into the general estate planning. And I hope the takeaway today is that you leave thinking you need a will and you put some action items in place to do that. Whether you use Willful or not does not matter. What matters is that you take care of this, and I'm going to walk you through all the different ways you can do that. If you do want to use an online platform like Willful, our goal is really to use, again, technology to make it easier to plan for end of life. How it works on our platform, you can think of us like the TurboTax for estate planning. So we work with estate lawyers in each province to draft all of the legal content so that it matches provincial regulations and so that it's kept up to date over time as laws change. You as the customer just have to go through and answer a simple questionnaire. So you don't have to worry about knowing the legalese or getting caught up in legal documents. You're just going to answer simple questions like, who would you want to take care of your kids if you were to pass away and they were under the age of 18? And then once you go through that questionnaire, it's going to populate all of your answers into a customized set of PDFs. And then you're going to be able to execute those to make them legal. In Canada, unfortunately, you do have to execute a will on paper. Digital wills are not yet legal, although because of COVID, provinces like BC are starting to pass laws that allow for digital wills. But in the meantime, you can review, print, and sign. And really, this process takes about 20 minutes, as long as you know the key roles that you want to appoint and the people that you want to appoint in those roles, which we'll talk about today. You can get it done sooner than it would take you to watch a 30-minute show on TV. So I saw a question in the chat about whether Willful can be used in Quebec. So we're active in 8 provinces. So the only provinces that we're not active in right now are Newfoundland and PEI, but we are hoping to launch there soon. We're active in every other province, and we have these 3 plans outside of Quebec. Quebec has a different legal system. So on the next slide, I'll just show you what plans we have there. So you can get a will for $99. You can get a will and power of attorney documents for $149. I'm not going to talk too much about power of attorney today just because we have a lot to get through, but a will comes into effect when you pass away. A power of attorney document comes into effect while you're still alive, but you're incapacitated due to illness or injury. So it's good to have both. One covers in case something happens while you're alive. One covers what happens when you pass away. You can get all 3 of the documents you need for $149. And we also offer free updates in future. So you can come back and make updates to your will or your power of attorney documents as your life changes without having to incur that additional cost. And we have a family plan where you can just bundle them together. So it will be, $250 for both of you instead of buying 2 separate premium plans. We do have a promo code for Enriched Academy members. You can use code ENRICHED at checkout for 10% off any Willful plan, and we'll remind you of that at the end of the presentation. If you're in Quebec, again, you have a bit of a different legal system. So we do have a fully bilingual offering in Quebec. We offer that $99 basic will, and then we also offer what's called a notarial will, which is unique to Quebec. It's a will that's executed by our partner notary in Quebec, and it's really the gold standard for wills in the province of Quebec. So again, we are fully active in Quebec and have a fully bilingual platform there, which is great, and you can use that code Enriched in Quebec as well. This is just a view of what the platform looks like. You can go through it on your desktop or on your mobile device, whatever's more convenient for you. And we provide a variety of support for you as you go. You can email, live chat, book a phone call with our team, etc. So I'll provide the support email at the end as well. Rena, I see a question here about will updates. I'm going to get to that a little bit later in the presentation, but thank you everyone for popping questions in. I promise I will get to them. Okay, so let's get into the general estate planning content. So there you have a bit more about Willful story. You have a bit more about the platform itself. But now let's talk about the basics behind creating a will in Canada. So you often hear the term estate planning. What does that actually mean? What is your estate? Well, your estate is simply everything that you own. So when you're creating your will, we're not going to ask you to itemize everything that you have. We're not going to say, what diamond jewelry do you have and what bicycles and musical instruments and investments, because your will doesn't typically contain a detailed asset listing. Your assets change too often. So you'd have to be updating your will every 6, 9, 12 months, which is just impractical. Your will instead covers your umbrella estate. So whatever you own at the time of your death, that's going to comprise your estate. And your executor is going to do the work of compiling a list of your assets and liabilities at that time. So why is estate planning important? It's really a blueprint your family can follow after you pass away. You know, when Kevin's uncle passed away, he had a will that said who got his stuff, but he didn't answer a lot of those questions outside the will about funeral and burial wishes and his legacy. And so when we say estate planning, I mean going beyond the will. A will is the crux of it. It's the most important document you can have, but it's also helping to pre-plan for some of those other things that you know your family is going to be looking to answer or take care of when you pass away. And it removes guesswork and arguing, which we definitely saw in our family. It reduces the length of time that it takes to wrap up an estate. Prince, the singer, passed away in, I think it was 2015, and his estate is still winding its way through the courts because it's so complex. In Canada, it typically takes about 12 to 18 months to wrap up an estate after someone passes away. And that's for a simple estate. So it takes a long time. And you're only shortening that time frame by having a will. Without a will, it slows things down by months. And you're also saving the court from appointing key roles. So if you pass away without a will, the courts are going to have to appoint a guardian for minor children. They're going to have to appoint an executor who's going to be the one that wraps up your estate and handles asset distribution and things like that. So it's just saving a lot of energy, time, headaches, and potentially also legal fees for your family. So I always say creating a will is not for you. It's like life insurance. You will never benefit from life insurance. It's really meant to protect the people you leave behind. A will is the same. It's a favor that you're doing for your family. So what is a will? Well, it's a legal document, again, a pretty simple legal document, typically between 7 and 10 pages, depending on your life situation, that dictates who will get your stuff and who will take care of dependents when you pass away. That's really it. It's not meant to be this massive behemoth, net worth statement or list of assets. It's really just saying, who do I want to get my stuff and who's going to take care of minor children or pets. So it's not as overwhelming as you might think. And bonus, you don't need to gather all of your financial statements and every single piece of paper related to your finances to create your will. It's really not necessary. All you need to sit down and create your will is the answers to some of these questions that I'm going to pose to you, like who would be your executor? So what actually makes a will legal? We always get questions. How is a will legal online? Don't I have to visit a lawyer? And I want to clarify that we are very pro-lawyer. If you want legal advice, if you have a complex situation, if you just want to use a lawyer, that's a great option to create a will. But a will does not have to be drafted by a lawyer, nor does a lawyer have to be involved at all in order to make it legal in Canada. What does make a will legal is that it has to be created by you. So you can't create one for your spouse or for your aging parent or for your adult child. You have to create it for yourself. And you have to be in sound mind. You have to have the capacity to create a will and to understand the implications of what is contained in the will. So for example, if you have a parent with Alzheimer's, let's say, it's not that they may not have the capacity to create a will, because they might have those moments of lucidity where they do actually have the capacity, but there are definitely going to be moments where they wouldn't have the capacity to create that will, which is also why it's so important to do it now while you are healthy and of sound mind, because if something does happen and you're not going to be able to get it done. So created by you in sound mind, it has to be printed and signed with a physical signature, because again, no digital wills in Canada. And it has to be signed by 2 witnesses who don't benefit from your will. So your witnesses can really be anyone. They can be two mentally sound adults, friends, neighbors, coworkers. They can be a married couple. They can be your cousins. They can be anybody. They just can't be someone who benefits from the will, because the point of witnesses is they're meant to be impartial witnesses who say, yes, Erin was in the room. I was in the room with her. I saw her sign the document. And if they benefit from your will, they may be biased in their motivation for being a witness. So that's really it. You can virtually witness a will in some provinces. I will caution that it's pretty convoluted. You can't digitally sign the document. So you would have to get on a Zoom call with your witnesses And then they would have to have a copy of the will. So you'd either have to mail it to them or print multiple copies. So it's a little bit complex. Often people just say it's easier to do it on paper, but if you have questions about virtual witnessing, happy to answer them. So what are the ways that you actually can create a will once you've decided, okay, I need one and I'm ready to do it? How you choose to create your will really depends on your budget, your life situation, and your comfort level. So the options on this page range from free to thousands of dollars. And the goal today is that you kind of take this away and decide which method is the right one for you. So the cheapest option is called a holograph will. That's a handwritten will. So literally just taking pen to paper and writing down your wishes. It's the only type of will that does not require a witness signature. So there's a famous story of a man who was at McDonald's. I don't know why his life flashed before his eyes because he was eating a greasy Big Mac, but he decided to write his will on a McDonald's napkin. And it was upheld after his death because it met all the requirements for a holograph will. These are not valid in BC. So if you're in British Columbia, holograph will is not going to be an option for you. And the thing to remember here is that the biggest challenge with a handwritten will is people don't know what to write. They don't know anything about estate planning. And so they'll write something like, I give everything to my husband, but then they won't appoint an executor. They won't add a backup. So in case they pass away at the same time as their husband, who's supposed to get all of their stuff? If they have a pet or a minor child, they may not appoint a guardian. So if you are going to go with a holograph will, just do some research on the types of things that you should be including so that it's as comprehensive as possible. Then you have DIY will kits. These are the types of paper kits that you would buy from a store like Staples. There are also some free government forms in some provinces. So you can just Google, free will BC, and you might be able to find some in your province. Obviously, make sure to check that they're from a reputable source. But these can be either free or they can be anywhere between $20 and $40 for one of those will kits. The challenge is they're not customizable at all. They're very fill in the blanks. And you also have to get a new one if you want to make updates in future, but very affordable option. And again, as long as you follow those signing and witnessing requirements, totally legally valid. Then you have platforms like Willful. We're not the only online will platform. There are others out there like legalwills.ca. And we are somewhere between that DIY will kit and a lawyer. So we're more customizable than a will kit. If you tell us you have kids and pets, you're going to get a very different experience and set of documents than if you don't have kids and pets. But we're not able to add as much customization as, let's say, a lawyer who can write in any sort of kind of customization that you need. And we're also not able to give legal advice. So like today's session, I'm giving you legal information. I'm not giving you legal advice. A lawyer can actually sit with you and give you legal advice specific to your situation. But obviously that comes with a price, both to draft the will up front, but also to go back and make changes in future. There's also the ability to visit a notary if you're in Quebec or BC. In BC, notaries have the power to draft wills. And in Quebec, there's a specific type of will called a notarial will, which must be executed by a notary. So if you're in one of those provinces, that's an option for you as well. So what can actually add complexity? We always say Willful is great for people who have simple situations. Just like TurboTax, you're using TurboTax to do your taxes when you don't have the world's most complex financial situation. If you do have a complex situation, you're probably hiring an accountant. It's the same with Willful. So what makes your situation simple? Well, our average customer tends to be, a Canadian with a spouse or who's single or divorced, someone who has kids or pets or neither, someone who has investments in Canada of various different types. The types of things that add complexity and may cause you to want to visit a lawyer or notary. You're separated but not divorced. This one is only complex because in many provinces, If you don't have a separation agreement that outlines what happens if one of you passes away, that ex-partner could actually have a claim to your estate when you pass away. So if you're separated but not officially divorced, always good to double check if your separation agreement addresses what happens in the event of one of your deaths, and to make sure it's addressed in there before you use a platform like Willful. Maybe you're a business owner. There's something called a dual will, which separates your business assets from personal for tax purposes. We don't cater to that on Willful. Maybe you have assets in other countries or even provinces. Sometimes people use this multiple will strategy to save on taxes. A lot of this comes down to, how can I save on taxes? Because yes, you still do have to pay taxes when you pass away. So we don't do that right now. We help you create a will in the province you live in. We're not going to help you create a second will in Argentina because you have a vacation home there. Maybe you need a complex trust. For example, there's something called a spousal trust, which means that you can leave money to your spouse, but when your spouse passes away, everything goes to, let's say, your children. This is really common with blended families. We only have one type of trust on Willful for minor children, and I'll get to that in a little bit. We have funny requests sometimes, like, I only want my nephew to get his inheritance if he graduates university. These are called conditional wishes, and right now we don't support those on Willful. And finally, maybe you just want legal advice. It's totally fair to say, Willful sounds great, but I just want to sit in front of a lawyer who can give me advice specific to my situation. I'll just feel better about it. Totally fair. And one thing to highlight is that we do have a 30-day refund policy on Willful. So if you do go through the Willful platform, even just to help guide you through the decisions you need to make, you can always, get your money back within 30 days if you change your mind and want to go to a lawyer. So what actually happens if you pass away without a will? Well, you have passed away what is called intestate, which is just a fancy word for died without a will. So what does that actually mean? Well, it means that there's a provincial formula that's going to distribute your assets. So I often hear from people, well, I don't need a will because if I passed away, everything would just go to my wife and kids anyway. Or everything would go to so-and-so anyway. And I say, well, do you know that? Have you checked the provincial formula? Because in Ontario, for example, if you have a spouse, everything would go to them. If you have a spouse and children, it would be split equally. And if your children were 2 years old and 4 years old, those assets, their inheritance, would be held in trust until the age of 18, which means your spouse wouldn't be able to access half of those assets for over a decade. So, you really want to check if that's your excuse. There is no good excuse for not having a will, but if your excuse is, well, it'll just go to so-and-so anyway, make sure that's the case. And for anyone out there who's common law, especially if you're common law in Quebec, it's even more important to have a will. Spouses are entitled to a share of your estate under that provincial formula, but common law spouses are not accounted for anywhere. And in Quebec, unless you have a will, common law spouses get absolutely nothing, even if you've been together for 30 years. So it's even more important to have a will if you are common law. If you die without a will, the court is also going to appoint a guardian for any minor children and appoint an administrator, which is basically an executor, to wrap up your estate. Again, this is just going to drag out the process. And those people might not be the people you wanted. Think of the absolute last person that you would want caring for your children, and then realize that if you pass away without a will, that person could apply to the court, and maybe the court thinks they're the best fit. So having a will is, again, the best way to put yourself in the driver's seat, to cut down on the indecision for your family, and to make sure that your assets actually end up in the hands of the people that you choose. So what are the key elements of a will? Now you've looked at all the different ways that you can make a will. You've hopefully decided that it's important to do because you want to have that peace of mind that your family is empowered. What do you actually do when you sit down to write your will? What do you need to know? So the first thing that you're going to do is to choose an executor. The executor is really the person who executes the wishes that you outlined in your will. They are your official voice after you're gone. And we have a question here from Nancy. What do you recommend for an executor if I have no children or close family? It's a great question. First, I wanted to highlight that most people look at choosing an executor like choosing bridesmaids for their wedding. They look at it as a popularity contest. So-and-so will get mad if I don't ask them, or, I should really choose this person because they're the closest to me. It's important to understand what an executor does and to not look at it as a popularity contest, but to choose someone who is actually equipped to do the role. So this is a big job. This person is going to be making a list of all of your assets and liabilities. They're going to be moving all of your assets into a trust account. They're going to be paying off all of your debts and filing your final tax return. They're going to be, if you have a house, for example, they're going to be responsible for clearing out your personal belongings and selling property. So it's a lot of work. And it involves an element of financial savviness. Now, your executor can hire an accountant, a lawyer, other professionals to help them through that process. But even still, it's a lot of work. And as I mentioned, it takes at least 12 to 18 months for a simple estate. So people typically choose their spouse or a close family member, that uncle who has been an executor a couple times and who's really good with money. They may choose a close friend, or they can choose a professional. So Nancy, to your question, if you don't have anyone that comes to mind in your own immediate personal network, you can actually appoint a bank, a professional executor, or a trust company as the executor of your estate. So it doesn't have to be an individual that you're close to. On Willful right now, we only allow you to appoint an individual just because if you're using a professional executor, they typically have a compensation clause that goes into the will, and it's not something that we can cater to, but it's a great option for people who actually don't, even if you do have someone that's close to you, you may not want to put that burden on them. So choosing a professional executor can be a good fit. The other thing to remember here is that just because you appoint someone as an executor in your will doesn't mean they have to do it. They might, if you pass away in 20 years, maybe they've moved to Australia. Maybe they've decided that actually it's just too much work. They have the ability to decline. And so what you want to do in your will is assign backups. So for me, I've said, okay, I want my husband, Kevin, to be my executor. He actually does know a lot about estate planning. I think he'd be good at it. But if Kevin and I pass away at the same time, or something happens to him and he can't be my executor, here are my backups and I've informed those people and made sure it's okay with them before putting them in my will, which is also important. So again, informing them is key. I have a lot of people say to me, oh yeah, I put my sister as executor. I guess I should tell her. I'm like, yeah, you should tell her because she might say no. She might not want that. So sit down with your executor or just even send them a text message saying, hey, is it okay? And also here's an article from Willful on what that actually means so that you know a bit more going into the role. And then most importantly, tell them where they can find the most recent copy of your will. The biggest issue with paper wills is lost or destroyed wills because people just don't know where people are keeping them. When Aretha Franklin passed away, her family found handwritten wills in the couch cushions about a year after she died because Aretha, I guess, just didn't tell them where those wills were stored. Not quite sure why she thought the couch cushions were a good place to put them. Great question from Nancy. Do they have to live in this country? So if your executor does not live in Canada, there are major tax implications because it changes the location of your estate. So if you choose an executor in the US or another country, I highly recommend speaking with a tax specialist before you do that so that you understand the tax implications of that. And if you do appoint someone outside your province, they may be required to post a bond against the estate to act in that role. I'm not going to get into the details, but essentially it would just be them putting up some of their personal assets as collateral to be able to act as executor. So we do have some content in our Learn Center about that, about appointing out of province or country executors if you're interested. We also provide free registration to the Canada Will Registry. There's no national will registry that stores all of the executed wills. In Quebec, for my Quebec friends watching, you actually have mandatory provincial registries. You're the only province that has that. But the Canada Will Registry basically allows you to say, my name's Erin, I created a will on September 9th, 2021, and I'm storing it in my couch cushions. If you passed away and your executor forgets that you had a will or where it's stored, they can search the will registry and find those details and track down that paper copy. So, always a good idea to tell your executor where it is, but if they forget, registering your will on the Canada Will Registry is a good backup. So the second thing that you're going to do is choose beneficiaries. So this is arguably the most important part of your will. This is you saying, all of these assets that I've worked so hard for my entire life, here's who I want to receive them when I pass away. Now you can pass things on to individuals, or you can pass things on to organizations like charities, which is something we're very passionate about at Willful. And it's not just the financial assets that you can pass on. You can also pass on things like sentimental assets, recipe books, heirlooms, things like that. So don't just think about it as passing on the money. Think about it as passing on anything of value to you, whether it has monetary value or not. You can leave a gift in your will in two ways. The first way is to leave a specific item to a specific person or organization. That would be me saying, I leave my wedding ring to my sister. I leave the family cottage to my brother. I leave my $5,000 to, my nephew. So that's really an identifiable piece of property or amount of money or the contents of a certain investment account that goes to a specific person. You can also, of course, leave a gift to charity. As I mentioned, we're very passionate about this at Willful. Only about 10% of Canadians plan to leave a gift to charity in their will. And I think the thing to remember here is when you donate to a charity when you're alive, you get a tax receipt, which reduces your tax bill at the end of the year. The same is true for donating to charity in your will. So as I mentioned, you can't avoid the tax man when you pass. Your executor will have to file your final tax return. And if you do donate to charity in your will, it's going to reduce that tax bill. So on Willful, we're proud to have over 7,000 gifts that have been left to charity, over $30 million in just cash gifts. And this is something that we see as a really positive thing that we can influence. So again, you can leave a cash amount, like I leave $5,000 to the Humane Society, or you can leave a percentage of what's left. So you've picked out all your specific gifts. Maybe you have none. Maybe you're like, I don't really have any valuables that I care that they go to the right person. Or maybe you have 20. I've had people ask me about baseball card collections and other, big collections of things that they want to make sure go to the right people. But after you've done that, you're going to divide your residue up by percentage. Residue is just a fancy word for everything that's left after specific gifts have been given out. So when you pass away, let's say I've outlined that my sister gets my wedding ring and that $5,000 goes to my nephew. Those gifts are going to be distributed first. And your executor is also going to pay your final tax bill, pay all your liabilities and debts. And as soon as those are all done, what's left is called the residue. It's the pot of assets that's left at the end. And you can divide that up by percentage however you like. So you can, leave 100%. A lot of people leave everything to their spouse. A lot of people will leave a portion to their spouse, some to their kids. Some people who don't have children leave 100% to charity, which is amazing. So you can really divide this up how you'd like. And again, it's all about appointing backups. So often people will say, especially in handwritten wills, I leave everything to my spouse. Well, what happens if you and your spouse pass away at the same time? If you haven't assigned backups to receive those assets, if that person is unable to receive it, you're going to default to that provincial formula. And it's almost like you didn't have a will at all. So in my will, I've said, okay, I want my husband, Kevin, to get everything. If Kevin passes away before me and I forget to update my will, or if Kevin and I pass away at the same time, here's who I want to get my assets. We also have on Willful a kind of ultimate backup called the contingent beneficiary. This is, just in case nobody else named in the will can receive your assets, this is a person, people, or organization who can receive it. So we guide you through that process on Willful of putting backups in place so that really the ultimate goal is there's always someone to receive the assets and you're not defaulting to that provincial formula. I'm just going to go to a couple of the questions here. Barbara, I agree. A mandatory registry would be great. So if you have any friends in the government, this would be a great thing, because as Rena says here, you have to think about things like fire and floods and destroyed wills when you have a paper copy. It would be so much easier if you could just either digitally execute it or register it in a central location online. But unfortunately, that's not the case. So yes, a lot of people get fireproof envelopes. I've even heard of people storing their will in their freezer, because the freezer is the most likely to not be affected by fire. The one thing I will say about storing your will is, if you're going to put it in a safety deposit box or a safe, make sure your executor knows that it's there and knows the code or access or has a key to get in, because it doesn't really do a lot of good sitting in a safe that they can't access. We also have a question from Amanda. Can executors and beneficiaries be the same people? Absolutely. So for example, my husband, Kevin, is my executor. He's also my beneficiary. So if I pass away before him, he would get everything and he would be the executor of my estate. Very, very common, but it doesn't have to be the same person. And then Barbara also mentioned, is it always 5% that's split between executors? So it's a great point. Executors, it's a big job. They are entitled to compensation. It's not as simple as 5%. It's actually a formula that is unique in each province that takes into account the size of the estate and the inflows in and out of the trust account where the assets are held. So I'm not going to go into detail on it, but essentially it varies depending on the details of the estate. But you don't have to leave anything to your executor in your will, because they are entitled by law to some of that compensation, and that will be approved by the courts. If you want to leave your executor a little something extra, you can of course do that, but you don't necessarily have to. And then I did have a question here about from Nancy about people with special needs situations. So typically, if you have a dependent with special needs and they're receiving disability benefits, you would create what's called a Henson trust in your will. And that basically protects them from being able to still receive government disability benefits, even if they receive an inheritance from a will. It's not something that Willful caters to at the moment, because as I mentioned, we don't handle complex trust creation, but that's absolutely something that you can do with a lawyer or a notary, depending on your province. And it's something we hope to be able to cater to in future. So I think those are all the questions so far. So I will keep motoring because we still have some stuff to get through. So speaking of children, I mentioned that parents are a big audience for Willful. And that's because, as soon as you have a child, or even when you're expecting, you realize it's not just about you anymore. And your will is really important for children because it helps you appoint a guardian for their care. And it also allows you to say at what age they would receive an inheritance. So you're going to be choosing a guardian to take care of your children in your will. And again, this is unlike an executor. It's not really about their financial prowess necessarily. It's more, a close family member or friend or someone that you think would be just the best parent for your child if you weren't around. This is easily the most difficult discussion that people have as part of their will. Kevin and I just had this discussion the other week. Should it be my sister? Should it be Kevin's brother? Should it be our friends? Some of them are young and don't have children, but we trust them. Some of them already have kids. Would that add too much of a burden? And then the whole, we don't want to be around I don't want to think about a world where our kids are around and we're not. So I get it. This is a really tough decision, but there's no perfect decision. The great thing about a will is that you can choose a guardian for your kids in your will, and you can come back and make updates to that anytime. And if you don't decide and put someone in your will, again, your family's just going to sit around arguing when you pass away. They're still going to have to choose a guardian. They're just not going to have your voice and your guidance. Again, it's important to talk to guardians, just like executors. Not everybody wants to become an instant parent. And just like an executor, they can decline the role. So it's also important to appoint backups in case that chosen guardian moves to Australia and it's impractical for them to take the kids, or their life has changed and it just doesn't make sense for them anymore. A key part of a will is also saying at what age your children should receive their inheritance. So if you pass away and your child is 10, Do you want them to get that at 18? Because I don't know that I would have been the most responsible with an inheritance at 18. On Willful, you can say you want them to get it at, let's say, age 21 or age 25, where they might be a little bit more mature with their inheritance. So that's a bonus as well. And then we can't forget about our furry friends. You are also able to appoint a guardian for any pets and to leave money for their care. Only about 6% of pet owners have actually planned for pets in their will, but it's one of the top reasons that pets end up in shelters, because their owners haven't planned for that and they've passed away and no family member steps forward to take care of them. So, especially for millennials who don't have kids yet, this maybe is one that resonates a little bit more. My mom, for example, has 2 horses. Those are not cheap animals. So she can appoint a guardian, but she can also say, okay, I'd like to leave that pet guardian, $10,000 to help to cover the ongoing costs of taking care of the horses. I'm going to confirm with you on whether this is taped, and you can watch it later, but I believe so. Jonathan asked if you pay taxes on gifts. The beautiful thing, Jonathan, about Canadian estate law is there is no inheritance tax. So if you receive an inheritance from a will, whether that's a gift, whether that's a cash amount, all of the taxes have been paid on that when it comes to you. The only exception is a mortgage. So if you've been left a house, let's say, that has a mortgage on it, either that mortgage is going to need to be transferred into your name, or you're going to have to sell the house, pay off the mortgage, and you would keep the difference. Other than that, though, when it comes to you, it's free and clear, which is very different from other countries like the US. Okay, so I'm going to move on here. I'll finish up and then we'll come back to some of these other questions here. So that's it. That's creating a will in a nutshell. You're choosing an executor, you're choosing your beneficiaries, you're choosing guardians for any minor children or pets, and that's really it. It's not actually as overwhelming as you may have thought. But one of the key parts that I mentioned earlier is keeping your will up to date over time. So we had a question earlier about, if I had a lawyer draft my will 5, 10 years ago, 20 years ago, can I use Willful to update it? The answer is no. We wouldn't update a lawyer drafted will because there's no way for us to load that content into our platform. But you can use Willful to create a new will that revokes the previous version, which is what a lot of people are choosing to do, just because coming to Willful and paying $99 for a will is cheaper than going back to that lawyer to add 1 or 2 changes. So when may you want to update your will? Well, these are the life changes that typically trigger that. The birth of a child, because when I have our first baby in a couple months, I'm going to add them as a beneficiary, and I'm going to add a guardian for their care. And there's no point in me doing that now because I don't actually even know what their name is yet. When I get married, in provinces like Ontario, fun fact, if you have a will and you get married, your will automatically becomes invalid. This is changing on January 1st, 2022. But until then, if that's you had a will, you got married, you haven't updated it, your will is actually invalid under the law. If you got divorced or separated, that's definitely a great time to update your will and get that X out of your will. Maybe you've purchased a large asset or something that you want to leave as a specific gift. I do want to highlight, you don't need to update your will every time you purchase a new asset like a house or a boat or a car, because again, your will adheres to your umbrella estate, everything that you own. But if you have something you want to give as a specific gift, I want this to go to so-and-so, then you would want to update your will. Let's say you move to a new province. Every province has different estate legislation. So on Willful, if you move from Quebec to Alberta, you can easily go in, update your province. It's going to update all of the legal content on the back end. Or someone named in your will passes away. Let's say you named an executor in the will and they've since passed away. You should update it and remove them and add someone else in that role so that your will isn't out of date. You can update your will in a few ways. Let's say you have that lawyer drafted will. You can add what's called a codicil with a lawyer. A codicil is basically an addendum. It's not something we cater to on Willful just because they're so customized. But if you created your will with a lawyer and you wanted to update it, they'll typically do that through a codicil. You can also execute a new will that revokes the previous version. This is very common. So essentially, let's say you created a will with a lawyer 10 years ago. You come to Willful, you execute a new will. It automatically, by law, revokes the previous version. And then you would just destroy the older version and make sure that you put the new one in the same place. You can also make handmade alterations on your will, but I really would caution there are specific laws around how to do this that involve having those changes signed and witnessed by the same witnesses who witnessed your will. So be very cautious if you are making handwritten changes to your will. On Willful, again, we offer free updates for life. So you can come back anytime and make updates for free. And you're essentially just updating a new version of your will. So the most annoying part is you just have to print and have it signed again. But the good part, it's totally free. So I really wanted to end off by just talking about the fact that a will is really just the tip of the iceberg. As I mentioned, Kevin's uncle, when he passed away, he did have a will, and it was really helpful to know where he wanted his assets to go. But there was all of these other questions we were left with. So a lot of people say to me, okay, great, I've finished my will. What else could I do to make life easier on my family or my executor? Which is great. I love getting that question. And so I'll take them through a few things like funeral and burial wishes. On Willful, we do ask you about your funeral and burial wishes and include them in the will. And they're not a legally binding aspect of your will, but most people don't talk about it. No one's sitting around at the dinner table saying, when I die, make sure you cremate me, except maybe Kevin and I, because we're a little bit into estate planning. But these can be stored in your will. They can be stored outside your will, a piece of paper or typed up, stored with your will. You can email your executor or family members with these wishes. But it's, things like we were struggling with, what did Uncle Dave want to be buried in? Would he want a traditional funeral home ceremony or not? So anything that you can put down around these things will just really help your executor, who's the one who's responsible for handling funeral and burial wishes. Same with things like digital legacy. We have never had bigger digital footprints, and you've probably all experienced having someone pass away on Facebook or LinkedIn and seeing their profile pop up on their birthdays and being a little weirded out. A lot of people don't think to plan around, what do I want to happen to my social media accounts? Does my executor know how to access them? Do you have any digital assets like cryptocurrency, and you need to make sure your executor knows where to find those things? I use a password manager called 1Password, which is a great Canadian company, to store all of my account passwords and logins. And I've shared that with my husband, who's also my executor. So I have peace of mind that if I were to pass away, he'd be able to log in and close up my accounts and deal with my digital footprint. But that can be really messy in 2021. And other information that you might want to store for your executor, a list of your accounts. So it doesn't have to be a list of, your bank account number, your passwords, but just saying, hey, I bank with RBC, and I have investments with Wealthsimple, and I have crypto with CoinSquare. That can just be breadcrumbs that helps your executor to create that list of assets, because otherwise they're waiting for mail to come in. They're checking your email if they even have access to it. They're looking at your former tax returns, and they might miss something. They might not know that you have crypto with CoinSquare, and so that's going to sit in the digital ether forever. So making a list of your accounts and investments is a great idea. Keeping copies of any policies, like life insurance policies, alongside your will. And putting any other wishes that you have in a letter to the executor. This is not legally binding. It's stored outside the will, but it can really help. And I have this very fun Google Drive folder called When I Die that has a lot of this information. I review it about once a year. I make sure it's up to date. And it really only takes me about 30 to 60 minutes a year to just go in and make sure that this stuff is up to date. So the bottom line is really, if you don't know the answers to a lot of these questions, how will your family know? And if you don't tell them where to find that information, how will they find it if something happens? So I'm going to leave this up. This is just a reminder of our support email. If you have other questions you didn't feel comfortable asking today or that come up after, you can reach out to us. And you can use code ENRICHED for 10% off any plan. And I'm just going to pop into I'm going to pop into the questions and make sure that I address them all before we sign off. So Amanda asks, can Willful handle leaving crypto to beneficiaries, or is that too complex a topic? Great question, Amanda. The answer is, crypto is considered an asset. So again, your will covers your umbrella estate. You don't have to specifically call out crypto as a unique asset in your will unless you wanted to leave the contents of your digital wallet as a specific gift. A lot of platforms like CoinSquare have policies for how they will allow executors to get access. So with CoinSquare, I did reach out to them because I was interested in this. You'd have to provide a copy of the will and a couple other documents to prove that the executor has the right to get your crypto transferred into that kind of central trust account or into the executor's name. But you don't have to specifically address it in the will. It would just be part of your umbrella assets. We have a question here about appointing a guardian outside of Canada. That's a great question. So we do have a lot of folks who are new Canadians or people who have a guardian that might live in the US. So the answer is yes, you can appoint a guardian for your children anywhere in the world. The only thing to note is that when you appoint a guardian in your will, it's only active for 90 days. After 90 days, the courts have to formally appoint them, and the court will take into account what's best for the child. So if your guardian is in Australia and you have to uproot the child and there's way more family members here at home in Canada, the judge might say, well, is this really what's best for the child? You can put a specific clause in your will that outlines why you're making that choice. It's not something that we do on Willful, but you can visit a lawyer to put in just some more reasoning behind why you want that out-of-country executor, and that will help towards showing your intention if the judge is making that decision. And I'm just looking here. Which online platform might handle self-employed people? Great question. So if you have a business, we have what's called a carry-on business clause on Willful, which allows your executor to step in and make any decisions related to your business. Wind down your business, sell it, etc. The only thing we don't do is create a dual will, which again separates your business assets for tax purposes. I don't know that there's any online platforms that offer dual wills in Canada, but if you are self-employed and you don't care about that dual will, you can absolutely use an online platform and your executor will be able to act on behalf of you in relation to your business. So I know I'm getting close here. It's 1:57 Eastern time. So I'm going to say a huge thank you to the Enriched Academy team for having me. If you have more questions, I will either answer myself or will escalate to our legal advisors if it's too complex for us. But either way, reach out at support@willful.co. And again, the takeaway today is get a will regardless of how you choose to. So I'll hand it back to you, Aaron.
Thanks so much, Aaron. What a jam-packed class. My gosh, so much information there. And, this is one of those topics, again, it could be awkward to talk to family members about this. Some may find it offensive. A great thing that all of you could do, just share this video with your friend, a family member, anyone in your life that you feel this would benefit, share it with them. So again, thank you so much, Aaron. What a great class. You're seeing a lot of thank yous in the comments section, which is amazing. And yeah, I think that you handled all the questions. You basically did my job. I didn't even have to be here.
Well, I'm sorry. I always try and answer them as I go, but yeah, we actually do have a great article in our Learn Center about talking about estate planning with families. So I'll also I'll send that over to you. So if you want to distribute that out, it's a great thing to talk about at the Thanksgiving dinner table.
Oh yeah, that is for sure. Let's see if I could pull it up here. Yeah, and they got a great website here, guys. Like if you take a look at Willful, they got great articles here. I'm not sure if it's this one, but if you go in the resources, the Learn Center, I was checking this out. Just
if you just type family in the search box, then that should pop up. It's a guide to talking about estate planning with family, which can always be a little tricky.
Yeah, absolutely. And yeah, this video is recorded, so you can definitely watch the replay. And please, guys, if you enjoyed this, give this video a big thumbs up and share it. One person, family member or friend, All you have to do is share it with them, and it could really change a lot of things that happen for them and their family members. Huge positive impact. So amazing. Well, again, Aaron, thank you so much for joining us, and best wishes on the baby coming soon, which is so exciting. So again, Aaron, amazing job here, knocked it out the park. You could see the thank yous in the comment section are just going, you know, everyone's saying thank you, and we'll definitely have you back. So thanks again, Aaron. Have a wonderful rest of your day, everyone. And we're back next Tuesday at 1 p.m. for another class. So make sure to join us, everyone. Thanks so much.
Thanks, everyone, for your time. Really appreciate it. Bye.
I